Very good. I see both counsel have entered the virtual courtroom. So we are ready to go. Counsel for the appellant, you may proceed.
Thank you, and may it please the court. My name is Michael Labby of the law firm of Phillips, Hayden, and Labby, and I represent the appellants, Hourglass Entertainment, LLC, doing business as Stingrays Bar and Grill, as well as Denise Carlosio and Eric Mattis. I would like to reserve 5 minutes for rebuttal.
Very good.
This is an appeal from an amended final judgment in a commercial eviction action, wherein the trial court awarded damages totaling $112,425.58. Within that damages award, $103,318.09 represented rent that accrued after the landlord retook possession of the premises, and an unspecified portion was accrued after the actual trial in this case and was awarded subject to an acceleration of future rent. The appellants are requesting that this court reverse the amended final judgment, in part to the extent that it awarded that approximately $103,000 in rent accruing after the landlord retook possession.
Mr.
And for
Labby,
remand, I'm sorry.
let's talk about the two different leases.
Yes.
Read your brief and understand the relief that you're seeking, and I think understand most of your theory of reversal. With respect to the parking lot lease, which is about 35,000 of the $100, using very round numbers, about 35,000 of the rent that was awarded, and that was for through the expiration of that term, right? The amount that the trial court awarded for the parking lot lease was until the end of August 2024, if I remember.
That's correct.
And the parking lot wasn't relet, only the building was.
That's correct.
So I get your argument on the acceleration, the problem with the lack of acceleration clause and options 1, 2, and 3, what the trial court could do with the parking lot lease in terms of awarding the rent. Where I have some questions for you is the theory of reversal on the building lease, because I agree, there's no acceleration clause. But I think and so the trial court couldn't have accelerated the rent through the expiration of that term and awarded rent at the time judgment was entered through the end of the lease term. But what the trial court did was award rent for the period during which the property was unoccupied and not producing rent, up to when the replacement tenant went in.
That's correct, Judge LeBrit. You point out a very good distinction with issue number 1, the lack of an acceleration clause. That issue is solely relevant to the amounts awarded under the food truck lease, because that is the only lease for which accelerated future rent, which accrued after trial, was awarded. Issues 2 and 3 apply to both leases.
And so good. Now we're on the same page of music, because I don't see the award of the building lease rent as being accelerated.
Correct.
And I also question whether it's fairly characterized as future rent, because by the time the trial judge entered this judgment, the new tenant was in and paying rent. And so what the trial judge did was effectively deem, and we can talk about this too, but what the trial judge did was effectively deem the landlord to have taken possession of the premises on account of the tenant and relet them, which it did. It mitigated its damages by doing that. And under the trial court's lights, it looks to me like the finding was landlord did option 2, which it's authorized to do. And the way the trial judge found out was by saying, they mitigated, they put in a tenant that paid the same or better on the second lease. And I understand your argument to be, well, they didn't make an election and the trial court didn't find that they performed that they elected option 2. So, and I think that's a lot of what we're talking about today. So,
yes, sir. And I think I would agree with most of that characterization. The term future rent really is not present in any of the legal authority. So I'll just use the words accrued, and the trial court did, under the building lease, only award rent that accrued after the landlord retook possession, but before trial. I completely agree with that. However, what I disagree with is the notion that the trial court found in any manner that option 2 was exercised, because there was really an absence of findings of fact in
Well,
the.
let's talk about that. The trial court did find that the landlord properly mitigated its damages, which is really the reason the option 2 exists, right? That's the purpose of allowing landlords to relet the premise, take it on account of the tenant, relet so that you cut off your damages. Now, to the extent you disagree that that finding is sufficient, you're an appellate lawyer, you know the rules. Where was the 1.530 motion to say these findings are insufficient?
I understand, Your Honor, that wasn't present in the record below, and I don't shy away from that. What I would say, however, is that the trial court's amended final judgment does not specify that the landlord properly mitigated its damages. Instead, in the amended final judgment, there's merely a notation that in March of 2022, the landlord began collecting rent from a new tenant. But the trial court doesn't make any specific finding with regards to the efforts that were undertaken, certainly not that those efforts qualified as good faith efforts. So, and I'll address that when I get to.
Good. I mean, I'm looking at the amended final judgment, and she said about blah, 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 after they breached, NRG was able to mitigate by finding a tenant in November 21. The lease payments did not commence until March 22. And then she goes on to explain the calculation of the 68,000 as being for the period that the property wasn't generating income.
Yes, Your Honor. Judge LaBritte said that they were able to mitigate, but there was no finding that good faith efforts were utilized, which is what's required under the case law. So I'll fast forward to that issue.
And you say you don't shy away from it, but the mitigation is really the purpose of option 2. So she got to the meat of the coconut and said mitigate. If you thought that it was a deficient finding because she didn't use magic words about good faith efforts, they had to do some effort because they got a tenant in within 6 or 8 months of the default of the vacatur by the first tenant. So they obviously did something. The tenant didn't just walk in and sign its own lease and say, "Hi, I'll start paying you rent," because I know you don't have anybody in here.
I would dispute that, Judge LaBritte.
She didn't make a specific finding that you now say is required concerning the nature and good faith of the efforts and the extent of those, but that's squarely within what Rule 1.530 requires, which is if you think the factual findings are insufficient, you need to bring it to the trial court's attention before you invoke our jurisdiction.
Understood. I'll address those in 2 separate points. The preservation issue I'll get to in a moment, but first, the suggestion that the trial court, there was no evidence, or there must have been some evidence that the landlord did something to relet. That's contrary to the landlord's own testimony. The owner testified that no efforts were undertaken. And
what they said was they didn't know if it had been marketed or assigned to a group.
They said that Joyce Turley, Your Honor, the accountant, testified that no marketing efforts were undertaken. And the person who eventually relet the property, and this is in the record, is the neighboring tenant. So
the vape shop. They knew somebody, and they were talking to the landlord somewhere along the line about it because the landlord signed the lease with the new tenant.
Yes, and with respect to the preservation issue, I would argue, this is really all I can argue with respect to that, is that the error here is a failure to carry the burden on the landlord's part. If they're going to follow under option 2 and say that we retook possession for the tenant's own benefit, they need to put forward evidence that they exercised good faith efforts to relet. And that's also contrary to the other evidence that they terminated the lease by appropriating the security deposit under the building lease, which is an action under section 6.02 of the lease that could only be taken if the lease had in fact been terminated. And we addressed that in our initial brief in issue 2, that under section 6.02 of the lease, the landlord could retain the security deposit if the premises were returned in a condition that was different than the condition they were originally let in. There was a suggestion of that in the landlord's closing brief. They explained that that is the reason why they retained Hourglass Entertainment's security deposit. Quote, because NRG provided 4 to 6 big screen TVs on the premises and that they were gone at the end of the lease, end quote. That action, when they go in and retake that, in 2021, and they say, we're going to hold your security deposit for this, they're exercising option 1 at that point. They're terminating the lease. That's the evidence that's in the record. So it's not only a lack of evidence in support of option 2, it's affirmative evidence in support of option 1. But even if I can't convince you of that, Judge LaBritte, the third argument would still win the day. And that argument is that there is no calculation in the amended final judgment as to the damages award, and there is no competent substantial evidence that would support the award of damages in this case. In the answer brief, the landlord pointed to 2 documents.
You have a stipulation that rent was unpaid and that the leases were extant and authentic between these parties. And then you get Carlosio and the bookkeeper to testify that they vacated, that the last payment was received on May 6th, and the term of the new lease began on March 21st. And the NRG admits business records, I think it was Exhibit 3, showing that, you know, what that monthly rent was. And then there's a rent statement that calculates and supports the trial court's findings of approximately 9.5 months and math on that, and another 9.5 months and math on that. So you don't need to hire Ernst & Young to come in and perform a month-by-month calculation. I mean, if you'd had Cam in here, we might have something to talk about, but the amount of rent that the lease called, amount of base rent that the lease called for wasn't really in dispute. It's specified in the lease, parties stipulated to it, the lease says it. They come in with a bookkeeper that says, here's what we were owed, here's what they didn't pay, here's when we started getting money again. How much more did they have to do to get?
Well, I disagree that that's what they did, Judge LaBritte.
To support the trial court's determination that these numbers, which came right out of the lease in the bookkeeper's mouth, and the spreadsheet that was provided, how much more did they need to do?
I disagree that that's what they did. At the beginning of trial, there was a stipulation as to rent that accrued in 2 separate months, one in 2020 and one in 2021. As far as all rents that accrued after the landlord retook possession, the bookkeeper, Joyce Turley, did not testify as to that, and that base rent changes annually based on the consumer price index. The 2 rent statements that were admitted into evidence, that was Plaintiff's Trial Exhibit 3 and Plaintiff's Trial Exhibit 4, were admitted by stipulation for the limited purpose only of showing the rent amounts that were previously stipulated to at the beginning of trial, the pre-retaking of possession rent amounts, the approximately $9,000. They were not admitted for the purpose of showing rent accruing
let's be real, right? She's calculating rent for 2021 with a CPI increase that was in place for the whole year. So if we know that the base rent amount was 6680.01, then what you need here is a calculator, not a bunch of evidence. So help me out with that.
I disagree, and I think what you're saying is that, well, under the building lease, then it's okay. Under the food truck lease, there's definitely not sufficient evidence because that CPI would go forward for several years since, again, there was an award of accelerated rent. But for the 9.5 months awarded under the building lease, I still don't believe it's sufficient because there would be late fees within there, and it's not shown how exactly that goes into the calculation, nor is it demonstrated how the first month's rent and security deposit was handled. Under the building lease, again, the security deposit was retained by the landlord. It was not applied or subtracted from the award of rent under the building lease. The trial court specifically said that in the amended final judgment, they were not crediting the tenant for the security deposit with respect to the award under the building lease. Why? Because the landlord had appropriated that. And what I would argue is by doing so, they could only do so by exercising option 1 under the lease agreement. Under the food truck lease, the trial court, Judge Peacock, did credit the tenant for the security deposit. So going back to my initial argument, I know we kind of moved past that one very quickly. I just want to point 2 things out. Number 1, in the appellee's answer brief, they suggested that something other than the de novo standard would apply. That's incorrect. What we're talking about here is the interpretation of the lease agreement, whether or not the absence of an acceleration clause would allow for an award of accelerated future rent. The appellee cites the Williams case, which we also rely upon, suggesting that that isn't the case, that you could still get an acceleration of future rent, even if there wasn't an acceleration clause. In fact, Williams states the exact opposite. In that case, the court says, let me find the exact quote here, that, quote, by its express provisions, the covenant is to pay rent in installments, not in lump, end quote. And then it goes on further to say, quote, since future rent is demandable only in the amounts and at the times named in the lease, the total cannot be recovered at law in a lump sum in advance of the accrual of the installments, end quote. That same analysis has been.
Let me just let you know you're at your 5-minute mark. If you want to reserve, you can.
I will go ahead and reserve then that 5 minutes and stop now. Thank you.
Very good. And Mr. Weiner, you are still on mute.
There we go. Thank you, Ron. May it please the court, Rory Weiner for NRG Investments. I'd like to start first by answering the question about what option this was, option 2. Your Honor is correct that the fact they mitigated gives us the evidence as option 2, but there was additional evidence. It was testified that because the screens, the TVs had been taken, they replaced those TVs, and that they were doing things to get it ready. So there were actions involved aside from just actually signing the contract for the mitigation. But I want to also remind the court that counsel in his reply brief says that his clients are obligated for future accrued rent. And I think the idea of acceleration sort of drops out here because, as Your Honor noticed, under the building lease, all the rent had accrued by the time, not only the trial, which was November 2023, and the lease had ended in March 2023, but by the time of the amended final judgment in April of 2024, the lease was over. So there's no future rent that needed to be accelerated. It was owed, especially the unproductive 9.5 months was already owed. If you take that analysis,
does that go to both leases or just the lease of the bar?
I think it goes to the food truck lease too, because when you look at the timing, the food truck lease ended September of 2024. The amended final judgment,
trial was when?
It was November 2023. But the final judgment.
So the food truck lease had not expired.
It had not completely expired, but by the time of the amended final judgment, there were 4 months left. 4 months left. And I think that if one did a present value calculation on 4 months, it would pretty much be de minimis. But I want to back up because I think the analysis of accelerated rent applying here through the Williams case is misapplied. And his references to the Williams case and his quotations, I think, are taken out of context. In the Williams case, the landlord had a 5-year lease, and the tenant breached early, and the landlord, instead of collecting by installments, he was taking a position that he was going to do nothing. The tenant was going to retain possession because they locked up the place. They didn't give him the keys. And so he was, at least the court said, he was possession constructively. The Williams court said, look, that's a third option. And where the landlord does nothing. And in that case, you got to look to the lease to see how you collect the rent. The lease in that case said installments. The landlord in that case wanted to get it all at once, wanted to accelerate it. And when the court referred to the lease, it looked at it and said, well, there's no provision of acceleration in the lease, only installment. That is not the analysis when you are in an option 2 situation where the tenant, the landlord has retaken possession. In that instance, the Williams court and even the Cantor court, they're both on, and Cantor was the Supreme Court about 10 years later, they both say.
Cut to the chase. What option did your client elect with respect to the parking lot?
2.
Two.
And yes. And because of
so
that.
If that's the case, then even though I understand what you're saying about the amended judgment being entered 4 months before that lease expired, so we're talking about $3,500 more or less. How could the trial, under option 2, since the parking lot wasn't relet, how does the trial court award the full term of the lease rent?
Because under Williams, and this is repeated in Cantor, under option 2, the damages are general damages. They're contract damages. And Cantor even says you can get your contract damages for past lease, for past award, or for prospective damages. And the example being, you get lost profit in the future. So in this case, the trial judge was awarding contract damages that were owed for the entire lease. And so I think the idea of acceleration is not.
That actually sounds like an argument about acceleration. That doesn't sound like an argument under option 2. Option 2 would be, did the landlord establish that it could not relet the premises, or that it did relet the premises, so there'd be credits. So I'm not sure you get future rents as an element of damages absent either an acceleration clause or showing that this property can't be relet for some reason after good faith efforts.
And I think in the first instance, I think that the contract damages award allows it. But on the second, which I think Your Honor is really focusing on, is that the food truck lease was a very special instance. It was conceived ad hoc. There's never been a parking space with a food truck on it. The tenants had no way of cooking hot food, and they want to have a food truck, and without permission of the landlord, they stuck one in the middle of the parking lot. He was furious, but he agreed, look, we can put it on the side of the building, next to the alley, next to the dumpster, and you can have your food truck. And that's how that ended up happening. That is not a situation where he's going to lease it to a third party. And we know that because in the lease that was for the new tenant, he puts it.
Thou shalt never use a food truck without express written consent or something like that from the landlord.
That's right.
And if we give you consent, maybe, it doesn't say something like a renewal option, may do this if the landlord approves or an assignment, may if reasonable, blah, blah, blah. It says, thou shalt not, unless we do it. So clearly it wasn't in the landlord's range of things they might like to do with that parking lot. But here's the thing, even with the 4 months, even with that, if we take it under your theory that, as of April 24, there's 4 months left on this lease and it was somehow general damages. The general damages are tied directly to the lease amount. And one of the arguments that your friend on the other side has made is that should have been reduced to present value if that's what you were, and I don't know if they make it directly to that point, but that's a concept in the notion of awarding the damages like what you're talking about. And that's not what she did. She didn't award general damages. She awarded the amount of rent that the lease called for through the expiration of the term, which is traditionally what we would view as acceleration, even for those 4 months. So help me out with that.
Yeah, the reason you wouldn't need a present value is because those months had accrued. They weren't future.
They had accrued. This was April. The lease went through August, and she awarded rent through August.
Sure, and that's why I was mentioning that there's 4 months that one could do a present value calculation for, but you wouldn't do it for damages that were not awarded in the future, where you need to know what they're worth now, because those up to April had accrued. And so I don't disagree that there are some future damages, but I think they're pretty de minimis in that situation. And if I could answer your question about the option to renew, I agree with you. He wants consent. He wants to give his consent before you get a food truck. And he had not gotten consent when they landed that food truck in the middle of the parking lot. This is a new provision in this lease for the same bar, the same spot, doesn't have a kitchen, and there's an opportunity. Now, you're right, he has control over that, but that's a new opportunity for the tenant to have a food truck, which would mitigate, but the evidence wasn't developed there whether or not the new tenant took advantage of that and used the food truck or not. My only point is that there was a step there taken. Now, the food truck, again, when you look at the lease and it gives that tenant the opportunity, the tenant, I believe it's saying that this is not a space that's offered to third parties, that we mitigate with third parties. This was a one-off. I'll give you a chance to have a food truck because you can't, have food that's hot in your bar. It's not a traditional, I have a food truck lease agreement that goes on and on and on. So I don't think that the concept in that instance of a good faith mitigation is really applicable. It's a one-off situation that he then puts into the new lease as an opportunity of possibly using it again for another tenant, but not to a third party, because this is a side of the building, a space on the side of the building, next to an alley. I don't know if that addresses Your Honor's concern, but I think that the food truck lease does receive contract damages, but you're right, it does through April, and then has some that may need present value calculation. But none of the building lease would require that, because that had expired before the trial. And so the acceleration analysis on that one is, I think, just moot. I mean, there's nothing to accelerate. These were damages that already had expired and were owing, not in the future, but now. And so I think that I think the building lease goes to that point. One other point I want to mention is that counsel talks about this stipulation. What he doesn't tell the court is on page 10 of the trial court transcript, when the two attorneys, the trial attorney and myself, were discussing the stipulation, we agreed that it applied to the two past due rents, but it didn't apply to consequential damages. And he acknowledges that himself on the transcript. In fact, in his closing brief, and this is why it was acknowledged, in his closing brief, I think it's footnote 17, 18, 19, he refers to Exhibit 3 to justify his consequential damages on a counterclaim that he had brought. But even more so, there's other evidence in the record. The defendant put into the record Exhibits 11 and 12, all of the checks that the defendants had issued and signed for every month of rent from the beginning to when they left halfway into May. All of that evidence is easily counted up, just like Your Honor said. It's just addition and multiplication. That, even if you said there's some kind of stipulation, that's sufficient evidence. That's competent evidence. All the checks, and when you do add them up, it's roughly what the court came to with using the annual rental agreements. I'm not sure how much time I have left, but I could address another issue if you need to.
You've got about 8 minutes left.
Okay. The other issue that the counsel brings up is whether or not these calculations were done with the proper method. He brings this up in his trial brief and says that somehow the method is wrong. This is just a method that is used when you're in option 2 for general damages. So I think the method is right. The calculation is right because, as Your Honor noted, the trial court found that there were 9.5 months that were unproductive and multiplied that by the latest effective date. The one calculation that I would concede the trial court got wrong was on the food truck. I believe she used 46 remaining months instead of 42. When you add up the checks and you look at the annual exhibit, they had paid 42 payments out of, not 42, I'm sorry, they missed 42 payments out of the 60. So they had paid 18. So the calculation should have been 42 times the most recent effective date on that most effective amount on that date that they finished their lease. So in that respect, I believe it goes from 39 to 37 if that calculation is done. And so, if Your Honors find that those are appropriate months to count, that would be the correct calculation. And finally, the CPA on the food truck, the lease clearly says that at a minimum, I want base rent. So there was no requirement that the CPA had to be calculated and added to the base rent. It was a requirement that I minimally get base rent throughout the lease. And so that calculation could be done easily. With that, I'll finish my presentation.
Very good. Thank you very much. Mr. Labby?
Yes, thank you, Your Honor. I'd like to go through this quickly. With respect to the acceleration argument, again, I want to point out I am only making that argument with respect to the food truck lease. I believe the absence of an acceleration clause wins the day for us, but even if there were an acceleration clause in the food truck lease, the second DCA's decision in Coast Federal Savings and Loan versus Deloche, which is cited in our brief, says, and I quote, "By retaking possession, either for his own account or for the account of the lessee, a lessor loses the right to recover the full amount of remaining rent due on the basis of an acceleration clause. The two positions are inconsistent," end quote. The reason why is because the first two options talk about retaking possession. So you dispossessed the tenant of it. You can't then accelerate all future rent that would be due, assuming they would still have the right to possession. So that secondary argument also wins us the day on the food truck lease. With respect to the accrual of rent on the food truck lease as well, the calculation, it's not just the 4 months after the amended final judgment to the end of the lease term, because there's no evidence, obviously, by definition, as to what happened after the trial date. So anything awarded after the trial date under the food truck lease would certainly be error. That would be accelerated future rent. With respect to the calculation under the building lease and whether or not those 9.5 months is just a mathematical formula that the court can do, I would posit that's not the case. The beginning term of the building lease was in March of 2018. The CPI adjustments happened on the 12-month anniversary. So the last payment when the tenant was gone was March of 21. There would have been an adjustment after the landlord retook possession based on the CPI index, which is not accounted for. Therefore, that calculation is incorrect. With respect to my lack of evidence argument, yes.
On the calculation of the base rent, of the rent due for the building lease, is it your position that the trial court incorrectly applied a CPI for 2022? Or did the trial court just use the CPI that was in place for 21 all the way through the March new rent start date?
My contention is that there should have been a CPI adjustment in 21 after the landlord retook possession.
So you want the damages to be increased in accordance with the CPI adjustment? I
don't want the damages to be increased, but what I'm pointing out is the failure to calculate damages and the lack of evidence here. And specifically, the testimony, again, never established what payments were made, not just what the amount of rent that was due, but whether or not any payments were made after the landlord retook possession. Ms. Turley's testimony doesn't go into that. The only evidence to support that was plaintiff's trial exhibits 3 and 4, which were admitted solely for a different purpose. They were admitted solely to establish the rent amounts that went unpaid prior to the landlord retaking possession. They were not admitted for either showing the amount that was due and whether or not any payments were made after the landlord retook possession. I know the court has suggested that, well, perhaps we already know what the base rent is. We could just do a mathematical formula. But again, it's not just what was the rent, it's whether or not the rent went unpaid. There's no record evidence of that post the landlord retaking possession. With respect to the absence of findings,
wouldn't that be an affirmative defense, though? Payment has been made.
That's a very good question, Judge Silberman. I think payment for past due rent that was accruing at the time that the complaint was filed, that would be an affirmative defense. But with respect to rent that accrued throughout the pendency of the case, I think that's a failure of proof on behalf of the plaintiff.
Is it, or is it a failure of the defense to then establish in its defense case that we've paid, here's the proof of payment? Even if it is not raised as an affirmative defense at trial, if there's now an issue of future rents that are being asked for, I understand the acceleration issue, I understand the issues as teed up, but if there's been payment, seems to me that's still something the defendant has an obligation to raise.
I agree that if there had been an initial showing that a prima facie case that payment had not been made, and I was going to argue, no, that's still an issue, we had made payment, then the burden would shift to the defense. However, the plaintiff must establish a prima facie case that there is some amount owing. In addition, I wanted to make a final point about the security deposit. With regard to the
make that point quickly because you're just about out of time.
Thank you. With regard to the nature of the repossession, that's a factual issue, and the trial court made no factual finding as to the effect of the landlord's appropriation of the security deposit under the building lease and whether or not that would suggest option 1 or option 2. Thank you.
Very good. Thank you both very much. You can exit the courtroom, but beyond that, that concludes our oral argument portion of the cases. So we are adjourned. Thank you all.
Thank you very much.
Thank you, Your Honor.